Okay, well, yeah, good morning, everyone. Once again, thank you so much for joining us on this Tuesday morning. I'm Hannah from the Spanish Chamber of Commerce, and I'd like to welcome you to this webinar that we're holding on the topic of UK immigration hiring overseas talent, which we're really pleased to be holding with Stevens and Bolton, which are a benefactor member of the Chamber. So I'm just going to begin by introducing the two speakers from Stevens and Bolton who are joining us this morning, Kerry and Jackie. So just a little bit of background about them. So Kerry Garcia advises on the full range of contentious and non-contentious employment matters, as well as business immigration. Kerry is a partner and head of the employment, immigration and pension practice at Stevens and Bolton. And she advises on strategic HR issues and contentious and non-contentious employment matters. Her experience includes drafting contracts and staff handbooks, advising on dismissals and termination packages, collective redundancies and reorganisations, discrimination, family-friendly rights, and advising in relation to and preparing for employment tribunal claims. We're also joined by Jackie Penlington, and Jackie deals with a wide range of UK immigration and nationality matters, from advising multinational corporates on their sponsor compliance duties to assisting individuals with their British nationality applications. Jackie joined Stevens and Bolton in 2014, having trained at a city firm and having worked at a niche immigration practice in London for several years. Jackie's previously spent time living and working abroad, which sparked her interest in immigration. She's experienced in relation to business immigration, especially sponsor license applications and sponsorships, and assist clients with more complex sponsorship issues, including where there's a change of ownership to the businesses. She also advises in relation to the EU settlement scheme, including settled and pre-settled status applications, which of course we're going to be covering this morning in the session. So just to let you all know, there's after Kerry and Jackie have finished presenting, there's going to be some time for the Q&A. Please feel free to write questions in to us at any point that they occur to you, but Kerry and Jackie will be answering those following the presentation. You'll see at the bottom of your screens, I'm sure everyone's very familiar with Zoom now and how it works, but there's a Q&A in the chat function, so in either of those, please feel free to write in your question and they will answer those at the end of the session. Yeah, thank you very much, and I'll now hand over to Kerry.
Thanks, Hannah, and thanks for joining us today. Over the next sort of 45-50 minutes or so, we're just going to really have a look at the impact of Brexit on immigration, because unfortunately it is still having, I think you'll find as businesses, very significant an impact because free movement has obviously disappeared. So it's now a case of looking at other immigration options if you want to hire somebody from outside of the UK. So we'll look in particular at sponsorship, but we'll also touch on a number of other routes which might be of interest to you. And those are both for temporary routes such as internships and also for permanent roles. And we'll look as well as part of that at the recent changes which were announced just this month and what those mean for businesses. And finally, I'll touch briefly upon business visitors, because unfortunately, even something as simple as a business visit has become a little bit more complicated post-Brexit. So without any further ado, I'll just pass over to Jackie.
Thank you, Kerry. So firstly, the impact of Brexit. We wanted with this slide to show you sort of before and after situation. So up to 11 p.m. on the 31st of December 2020, up to the end of the transition period, it was really straightforward. European and Swiss nationals could just come to the UK airport or port with their current EA or Swiss passport or their current EA Swiss ID card, and that was enough to come and live and work in the UK long term. And that was the position, as I said, up until that 11 p.m. on the 31st of December deadline. So it was really straightforward. There was no red tape, there were no visa fees. It was all very straightforward for both European nationals, family members, and also UK employers. Comparing that with the position post-transition period, so effectively from the 1st of January 2021 onwards, European and Swiss nationals who are arriving for the first time after 11 p.m. on the 31st of December, so not including those who've already had some residency in the UK, those individuals arriving for the first time to live and work in the UK are generally going to have to find a UK immigration route to qualify under to do so. In many cases, most cases, you'll find that will be the sponsorship route, which we will be looking at in more detail later on in the presentation, and we're going to flag some other routes as well that may be available. But obviously, visa fees, red tape, bureaucracy, it's much more difficult. It's worth just flagging as well that for Irish nationals, they're unaffected by Brexit and that they can continue to be able to come and live and work here just on the basis of their Irish passports. So we wanted to really just look very briefly at the EU settlement scheme, which was brought in March 2019 for European and Swiss nationals, and covers two categories of people. So firstly, the European Swiss nationals and their family members who were actually in the UK physically present before that deadline of 11 p.m. on the 31st of December 2020. But it also covers joining family members. So a family member who is joining a European or Swiss national who themselves is covered under this EU settlement scheme. And the relationship generally must have existed by that deadline, although it's slightly different for Swiss nationals. It also covers any children born subsequently to the European national or a family member. So for that first category, those European Swiss nationals and family members who were already physically present in the UK by that deadline of 31st of December 2020, they had a deadline to apply under the European settlement scheme, which was last year, so the deadline of 30th of June 2021, to be able to continue living and working in the UK long term. Clearly that deadline's now passed. It is possible if you have individuals in the UK who haven't submitted an application yet. Late applications are possible in some circumstances, but it's definitely worth getting advice before any applications submitted late. So in terms of what status individuals obtain when they apply under the EU settlement scheme, it depends on how long they've been living in the UK. So for those who were continuously resident in the UK for 5 years, they will get something, or they should get something called settled status, effectively permanent residency status. For those individuals who applied who hadn't yet been in the UK for 5 years in a row, they will have got something called pre-settled status, which is a temporary form of status valid for 5 years. And those individuals then need to, as soon as they get to the 5 years residency period, have to submit another application under the EU settlement scheme for settled status, so they get to that permanent residency stage. And what they mean by continuous residence is, has the individual spent at least 6 months of any 12-month rolling period in the UK throughout that 5-year residency period? And that's relevant because there's a few things to flag in terms of pitfalls. So where you have an individual who has pre-settled status, firstly, they need to be aware that can be lost if they're then out of the UK for 2 years in a row. Essentially, it's sort of cancelled. But also those individuals with pre-settled status, they need to safeguard their journey towards settled status in the UK. So if they have pre-settled status, they really need to keep an eye on their absences out of the UK, because as we've seen, if they're out of the UK for more than 6 months in any 12-month period, that's going to break their continuity of residency for that settled status application. And they could be in a position where they can't apply for settled status. And at the moment, it appears they can't extend their current pre-settled status. So it's all absences out of the UK, holidays, business trips. So in particular for UK employers or for individuals themselves, they need to be careful about any secondments overseas. You know, perhaps they're working at their sort of holiday house overseas, or any lengthy trips outside. They need to keep an eye on how long they're outside the UK. We wanted to flag as well for UK employers with the right to work checks. So from the 1st of July 2021, actually UK employers need to check that those European Swiss nationals actually have the right to work in the UK. You can't just rely on their current EA or Swiss passport any longer. They're not retrospective though, so if you've already employed someone up until the 30th of June 2021 on the basis of their passport, you don't need to go back and do another check. We also have seen quite a few queries from clients of ours about the right to work check for European Swiss nationals or family members who have settled or pre-settled status. And it isn't sufficient to just see the letter that they have confirming settled or pre-settled status. The UK employer has to go through the very prescribed right to work process to actually check on the Home Office portal that that individual has the right to work. So there is a very prescribed process that you need to follow, and you can't just look at the letter and say that's sufficient. So looking now at options for hiring overseas nationals, if the individual doesn't have pre-settled or settled status, we're going to focus in particular on sponsorship, because as we've seen post end of the transition period from effectively the 1st of January 2021, those European and Swiss nationals who are arriving for the first time in the UK are going to have to find a UK immigration route. And often this is the sponsorship regime. You can see here from this graph that we've included just the huge rise in sponsorship visas, called skilled worker visas, here from January 2021 onwards, and that has increased up until the current day. So that really reflects the fact that European nationals are now have to apply potentially for sponsorship or a different route. I'm going to pass on to Kerry now, who's going to talk in more detail about the sponsorship routes.
Jackie. So as Jackie said, this really is key post-Brexit, and of course it's now possible to sponsor European nationals as well as non-European nationals. The first sort of key message is that in order for you to be able to use this route, the company has to have a sponsor license. So there needs to be a trading UK company with a sponsor license. And I know that a number of the attendees on this call, your companies already have sponsor licenses, but it seems a number don't. Those that don't, it's definitely worth thinking about applying for one, potentially sooner rather than later, if there's any realistic chance that you're going to want to hire non-UK nationals. And that's because there's quite a long lead-in time. It tends to take, in our experience, a good month or two to collate all the documents for the employer to do that. And then it takes the Home Office around 8 weeks to process the sponsor license application. So you don't want to be in a position where you find the ideal candidate and then have to say to them, sorry, you've got to wait about 4 months before we've got a sponsor license. So that's just worth thinking about. Sponsorship is, I'm afraid, despite all the administrative burden and the costs, which we'll have a look at in a minute, it is viewed by the government and the Home Office as a privilege. And the reason I mention that is that in return, the quid pro quo is that the sponsors are expected to undertake quite onerous compliance obligations around both record keeping and reporting. So if you have a sponsor license, or if you're going to apply for one, it's really, really important to understand what those duties are and to make sure that you're in a position to comply with them, because otherwise you risk losing your license if the Home Office pays you a visit and discovers that you're not complying with them. So that's just something to be really aware of. So looking in a little bit more detail on the next slide, there's two main routes. So you have your sponsor license. You then need to ask, under which of these routes am I going to sponsor somebody? Most often we use the skilled worker route for our clients. And this route is far more flexible because it's available both to brand new hires, but it's also available if the person is already working for an overseas company and you're bringing them across to work in the UK for the same group. The big plus with the skilled worker one is that it leads to what we call indefinite leave to remain, or settlement. So it's a route to being able to stay in the UK permanently. It's also got a fairly low skills threshold, so the person needs to be undertaking a role which is at what we call RQF level 3, which is basically an A-level equivalent type of role. And the minimum salary is £25,600, or in some cases a higher sum depending on the actual job which the person's undertaking. The main downside we find to this route is that the person has to be able to speak English language to a fairly reasonable standard. So if they don't speak English, they're not going to be able to use this route. Which brings me on to the senior or specialist worker route. This, for those of you who are familiar with the sponsorship regime, this is basically what was previously called the intra-company transfer, or ICT route. They've just rebranded that as part of the recent changes. And this is really for people who are working for an overseas group company and you want to move that person over to work for the UK company. The key thing to bear in mind is it's got a higher skills threshold, so it's really a professional or managerial role, a significantly higher minimum salary. You can see on the slide £42,400 per annum. And most importantly, it doesn't lead to settlement. So it is a temporary route into the UK. But the reason it's sometimes used is that there's no English language requirement. So if you need to get somebody over from an overseas company to your UK company, they don't speak very good English and they're only coming temporarily, then this is probably the best route for you. But it's just making sure at the outset you're using the correct route is quite important. So just moving on, I've touched on the first two of these. Also, one of the key things the Home Office looks at is this concept of a genuine vacancy or genuineness. And a genuine vacancy basically means that you're not just creating a job so that the person can come to the UK for their own personal reasons, like to school their children here. So the Home Office might look at things like the size of the company and is there sort of a realistic business case as to why you need this particular job? Does it make sense given the size of the company and other employees? They'd also look at things like what's the role? Does the person have the skills and experience for the role? So there is quite a bit just to think about there that's sometimes challenged by the Home Office. I've touched on the timeline for getting the licence, but there's also obviously processing time. Once you have the licence, you issue what's called a certificate of sponsorship to the person, and the person then applies for their immigration leave. If they're applying outside of the UK, at the moment it's taking a good 3 to 6 weeks for the application to be processed. And that's because unfortunately the priority services have all been cancelled or suspended at the moment. And that's because the Home Office is diverting its resources to dealing with applications for Ukrainian refugees. So we're finding it's taking quite a long time for business applications to be dealt with. If the person's applying from within the UK, and there's some limited cases where they can do that, then there is a priority service still available, and it's possible if you pay the extra for the application to be processed within either 24 hours or 5 working days. So a lot quicker from within the UK. We'll look at the other two issues in a minute. So one of the key things is, as Jackie mentioned, the cost. There's no two ways around it. Sponsorship is really expensive. So you can see on this slide the cost for a medium or a large company to sponsor somebody for 5 years. And we've got the example of where you just sponsor the individual. And then the second one is where the person has, let's say, a wife and 2 children. So costs are really significant. If the UK company is what's called a small company, and you use the accounting definition for this, so it's based on number of employees and revenue. So if you're a small company, these costs will be quite a bit less. But still, unfortunately, one of the real downsides to Brexit is the sheer cost of now hiring European nationals in the UK. So just thought I'd flag that. Very briefly, as I mentioned at the outset, you have these quite onerous sponsor compliance duties. And this is really a topic in its own right, so I won't say much. But this slide sets out some of the key record keeping obligations. And also just to flag that you need to keep quite specific evidence about the recruitment process that you undertook. And we're finding when we're doing audits that lots of employers aren't realising this. So it's just worth double checking the latest guidance and making sure if you sponsor anybody, you are definitely keeping the right documents. So if the Home Office comes to visit, you have those on file. And then similarly, sponsor reporting obligations, the main ones are set out on the slide. And you've got an obligation as a sponsor to notify the Home Office, usually within 10 working days of each of these changes. And in some cases, it goes further than that. So for example, if somebody changes their role significantly, they might actually have to apply for fresh immigration leave that can trigger the need for a new application. In some cases as well, if you have very significant changes to your business structure, so let's say your immediate parent company of the UK sponsor changes, that can trigger the need for a new sponsor license application. So it's just to highlight, if you've got any of these changes, we'd always recommend taking advice as to what you need to do to make sure you remain compliant. And with that in mind, for those of you that do have a sponsor license, I just thought I'd flag some of the issues that we're seeing sort of time and time again as we emerge from the pandemic and people start coming back into offices. Just think about an audit of your license. So what's changed in the last 2-3 years? Have you closed any offices? Have you opened new premises? Have you got new overseas entities? Make sure you tell the Home Office of those changes. And then one that's often forgotten is if you've moved to any form of remote working, whether it's part of the time or all of the time, you really need to make a notification to the Home Office if any of your sponsored workers are now working remotely. That's quite important. And just think about how you'd comply with your duties when people aren't coming into the office on a day-to-day basis. If you've had any changes to the people who operate the license, really, really key that you tell the Home Office urgently. That is a way in which you could otherwise lose your license. And as I mentioned earlier, just be aware if your business structure or company ownership's changed, that can have a real impact on the license, and there's work that needs to be undertaken there. So that's really just sponsorship, which is a huge topic, but it's sponsorship in a nutshell to give you an overview. And Jackie and I are now just going to look at these other available routes. And Jackie will start with the first 3 routes.
Kerry. So we're going to look first at a temporary route for internships. This has been coming up more and more post December 2020, as we have clients suddenly realise actually a European national can't just come in on their current passport and undertake an internship anymore for them. So in terms of the process to sort of essentially sponsor someone for an internship, the UK employer that has the internship has to first register with an overarching sponsor, and there's sponsors such as the Tier 5 intern scheme is one that we've used for clients previously. It is more straightforward to do that registration process if the UK employer already holds a sponsor license, but it's it's not too document heavy to register anyway. And then it's the Tier 5 intern scheme or the other overarching sponsor scheme that actually then assigns what's called a certificate of sponsorship to the individual you want to bring in for the internship, and the individual then uses that certificate of sponsorship to support their visa application and apply for this temporary worker visa to undertake an internship in the UK. That individual has to either already hold a degree or be studying at the time towards a degree that's equivalent to a UK bachelor's or above. And the maximum period you can have someone under this internship scheme is 12 months. But obviously it could be shorter if need be. It's really important that the internship for the UK company is what's called supernumerary. So in addition to your usual staffing requirements. So this internship scheme can't be used to essentially provide extra headcount for a temporary project where you need more people. It's very much in addition to what your usual headcount is. And it can't be an unpaid internship either. So the individual who is being sponsored as an intern has to be paid at least the minimum UK national minimum or living wage or above. As part of the process, the Tier 5 intern scheme will ask for an internship plan. So they will want to see, what experience the individual will acquire as part of the internship, and also to see what supervision is in place throughout the internship. And the UK employer, although you're not the one who is effectively assigning the sponsorship, a certificate of sponsorship, you do have to comply with those reporting and record keeping obligations, such as sending monthly pay slips to the Tier 5 intern scheme, keeping contact details up to date for the intern, etc. We're going to now look at another temporary route, which is called the graduate visa route, which you may have come across. This is only available for individuals who've studied in the UK under a Tier 4 student visa. It's not a sponsored route, so in some ways that's a plus if you're it's less costly for the UK employer. Often individuals have sorted out their graduate visa on their own anyhow. And if it's successful, the individual has leave to stay in the UK generally for 2 years after they've completed their UK bachelor's or above course, or if it's a PhD qualification, they will get 3 years under the graduate visa route. It's an application that has to be made here in the UK, and it has to be made before their current student visa expires. So that's really important. And you can't extend it once the 2-year, 3-year period has expired, but it's a useful bridging visa to enable individuals, you know, to develop their career and potentially switch into a sponsorship route, you know, towards the end of their visa. They can work for any employer, any skill level, part-time, full-time, or be self-employed under this route, so it's quite flexible. But as I said, it's a temporary visa, so it doesn't in itself lead to any permanent residency rights, lead to indefinite leave to remain in the UK. So it's very much sort of gives them extra time in the UK, but isn't one to essentially settle them here. Another one, a visa category we wanted to flag, which may be very helpful for those on this webinar, is called the Frontier Worker Permit, and essentially allows eligible individuals to continue to live overseas, but to commute to the UK to work or undertake self-employment. So it's only available if the individual meets all of the criteria, which is in terms of nationality, an EA or Swiss national, secondly, be primarily resident outside the UK. And thirdly, they must have actually began working or being self-employed in the UK by that cut-off period of 11 PM on the 31st of December 2020. Generally, they must have also since then been coming into the UK at least once every 12 months to undertake work or self-employment as well, although there are some COVID concessions in place where that hasn't been possible. It doesn't lead to any permanent residency rights, but individuals can bring dependents with them. So again, it's quite flexible. It can be quite a complex application and quite document heavy. So it's one of those ones where if someone is potentially eligible, you know, start the application in good time, get advice, so it's all kind of properly structured. On the plus side, it's a free application, there's no visa fee, and if it's successful, the individual would get a 5-year permit. There isn't any deadline to apply as well, as long as the individual meets that criteria. And it is quite a flexible route in that it encompasses quite a few different working patterns. So it's definitely worth seeing if the individual could apply under this route. I'm going to pass on to Kerry now, who's going to look at some of the new immigration routes that we've just had come into the immigration rules.
Okay. So just briefly setting out on this slide, we had a whole tranche of changes announced in April. And the first set of changes is this whole new category called Global Business Mobility Routes. You might see that in the press. It actually comprises 5 routes, which I'll look at in a minute. There's also another new route called the Scale Up route, which Jackie will look at briefly, and the High Potential Individual route, which I think is perhaps the most useful of the routes. It's got its limitations, which Jackie will chat through, but it does enable individuals, or some individuals at least, to come to the UK without the need for sponsorship. So that's quite useful. So in terms of the global business mobility, as I mentioned, there's 5 separate routes. We've looked at the first one already because they've now moved intra-company transfer, it's now called Senior Specialist Worker, into this umbrella called Global Business Mobility. There's also the old intra-company graduate trainee route there, and this is very specific. It's where you've got a graduate training programme and you need to bring people from a UK company, sorry, from an overseas company to the UK to complete a graduate training programme. So it only applies in limited cases. And then we'll have a look at the last 3 on the slide between Jackie and me shortly. So kicking off with this UK expansion worker. Apologies to some of you because this is not going to be relevant to quite a few of you, but I'll mention it anyway, given the nature of some of the other attendees, it might be interesting. This is really a category where you've got an overseas business and that business wants to expand into the UK. And as part of that expansion, you want to send a number of workers over to the UK to help set up the business. So that's what it's intended for. And importantly, the UK business mustn't have started trading in the UK yet. So if you've already got a trading UK presence, this clearly isn't the category for you. You do need to have a footprint in the UK, and that basically means you need to either have some premises so signed a lease or a license or bought some premises, or you need to have set up with Companies House and registered a wholly owned subsidiary company or a branch office. So it's at that stage in the UK expansion. It's a pretty document heavy application because the first step is that the UK company or the business has to apply for a sponsor license under this category. So it's a bit different to a normal sponsor license application, because what you're really showing is that the overseas company's been trading, and usually you have to show trading for 3 years, and you need to provide evidence of a credible UK expansion plan, as well as funds to cover the first 12 months of the startup costs. Then in terms of the individuals, they need to be working for the overseas company already. In most cases, they need to have worked for that company for at least 12 months. And it's the same salary and skills threshold as set out in that table for senior and specialist workers. And one of the key things is that this only leads to a maximum of 2 years in the UK. So it's a temporary route here, not a long-term route. So if somebody wants to stay here long-term, they would eventually need to switch to a skilled worker visa. Once the UK company is trading, it would apply for that sponsor license and the person would switch into that category. So that very briefly is this new UK expansion worker category. Then we have another one called the service supplier route, which again, I'm afraid all of these are unnecessarily complicated in our view, but there we go. This is really designed where a UK company has entered into a contract with an overseas company or with somebody who's self-employed and based overseas. And either the overseas company or the self-employed person is providing services to the UK company. And crucially, those services need to be provided under a contract which is covered by one of the UK's trade agreements. So the very first thing that you'd usually do if you're looking at whether this might apply is you would look at what's the service which is being provided. Then you would look at the Home Office guidance, which has a long detailed table, and you would then look at, is that covered by a trade agreement? And if so, by which trade agreement? Because that impacts how this all works. So assuming that you potentially are able to use this route, what it then allows is the individuals who are employed by that overseas company providing the services, or the self-employed person providing the services, to be able to come over to the UK for potentially up to 12 months to provide the services to the UK company under the contract. And the slightly odd thing here is that the UK company, because that's the company with a presence in the UK, they have to have a sponsor license under this route, and they act as the sponsor, even though they don't actually employ the individual themselves. Importantly, they also have to make sure they've registered that contract with the Home Office. The other thing which limits this role is it has to be generally professional services. There's a few exceptions, but the role which the person undertakes has to be a professional managerial role, or in some cases they'd need a degree or technical qualification and 3 or 6 years experience. So it's really for that type of sort of senior managerial kind of service. So again, a little bit limiting. And depending on the trade agreement, there's sometimes residency and nationality requirements too. So particularly complicated route, but I mention it because it might be useful if you're either a business based in the UK and you've got a contract with an overseas company providing you with services, or you're a Spanish company based only in Spain and you provide services to the UK company. Either way, you might want to explore this further. So I'll pass on to Jackie for another, I'm afraid, fairly complicated route called the secondment route.
Thanks, Kerry. So this is a new route, the secondment worker route under this global business mobility umbrella, which is designed apparently to allow individuals to come for a temporary work assignment. Again, it's a temporary work route where they are being seconded as part of a high value project by their overseas employer. So as with the service supplier route that Kerry's just been talking about, it's the UK company that is the sponsor. So that UK employer, or the UK sponsor rather, has to first have a secondment worker route under a sponsor license. So they'd have to apply for that first. And the secondment has to be connected to a commercial contract worth at least £50 million. and the contract again has to be registered with the Home Office before someone can come under this category. So looking at the guidance, the latest guidance, it looks like the contract can be a series of contracts as long as there is a contract worth at least £10 million per year, and in total it adds up to £50 million. We're doubtful, as Kerry said, with the other one, service supplier, that this is going to be too much use to individuals and businesses in the UK. But you know, it is there again, is a temporary route, so it would allow secondees to come for up to maximum of 2 years if they extend after the first year, and it wouldn't lead to any sort of permanent residency rights for the individual being sent across. There is also, as with service supplier, the requirement for that individual being seconded to have been an existing employee of that overseas business which has the contract with the UK sponsor for at least the last 12 months. So we won't say too much more about that one, but it is there in case it might be of use. As Kerry said, this new route, that's called the high potential individual route, is arguably more useful for individuals and UK employers. It hasn't come into force yet, so it's due to launch on the 30th of May next month. And it's limited to graduates from top global universities. So there will be a list on the gov.uk website with a list of the qualifying universities. They need to have a degree basically from an institution that is ranked in the top 50 in 2 of the 3 ranking systems they use. So it will be a case of checking that list on the gov.uk website. And importantly, the degree that they have received from their university, which it must be equivalent to a bachelor's or above, must have been awarded in the 5 years before the application, and the institution must be on that list for the year that they were awarded the degree as well. It's an unsponsored route, so minimal cost really for the sponsor, the UK employer here, because I think the fee is going to be, visa fee is going to be about £715 plus the NHS payment of £624 per year. And if successful, individuals will have either 2 years in the UK or 3 years if they've had a PhD qualification. As I said, it's a temporary route, so it won't lead to settlement, to indefinite leave or permanent residency rights. But again, it could be quite a useful bridging visa to enable people to continue with their studies or their career in the UK and build up contacts. They will need to meet other requirements like the English language requirement, the financial requirement, and if they're applying from certain countries, submit a valid TB certificate as well. But yeah, we're more excited about this route. It's arguably going to be more helpful for individuals and UK employers. The scale-up route, again, is a completely new route that is opening in August this year, and intended to help UK businesses to scale up, to continue to grow. There hasn't been any detailed guidance as yet. Often the Home Office publishes that just before the route opens. But we anticipate that businesses will need to register as a sponsor, as a scale-up sponsor, and as part of that, they will need to show that either they have annualised turnover or staffing growth of 20% or more in the 3 years prior to the application, or and that they've had at least 10 employees at the start of the 3-year period as well. So it's, you know, it's fairly limited in terms of what business qualifies as a scale up. On the plus side, there's no immigration skills charge payment. So that's the payment that employers have to make under the sponsorship, under the skilled worker category or the senior specialist worker category, which can be up to £1,000 per year of the visa. So that's a bonus. But we anticipate that in order to apply as a scale-up sponsor, it's going to be quite document heavy to show this annualized turnover or staffing growth. So that may well sort of cancel out any savings on the immigration skills charge. Interestingly, the the UK employer only has to commit to sponsoring for the first 6 months, and after the first 6 months the individual can then be unsponsored and essentially work for a different employer, so they wouldn't be tied to the UK employer in the same way, but it's arguably not going to be too helpful a route either. So for some other categories, we wanted to flag these, but not in too much detail, but really just to sort of, explain that they are here and they may be helpful depending on the circumstances of the individuals coming to the UK. So ancestry, as you can see from the slide, it's only where the person is a Commonwealth citizen applying from outside the UK. So not directly relevant to obviously European or Swiss nationals, but you can apply as the dependent of an ancestry applicant. So, you may have a European spouse or child that's applying as a dependent of someone who's applying for ancestry. But it's a helpful category in that it gives individuals 5 years in the UK and they can undertake any work here as well. The other one we wanted to flag, which you may have come across, is called the Youth Mobility Scheme, essentially the Working Holiday Maker Visa, as it used to be called in days past. So just for young people who are defined as between 18 and 30, certain countries participate in this, and it gives individuals 2 years in the UK to undertake any type of work or self-employment. So you've got countries on the list at the moment. There's about 11, like Canada, Australia, Hong Kong, Japan, India and Iceland were just recently added this year, and there are different provisions for Indian nationals, so you have to go through a slightly different process, and some countries have a ballot system, so yeah, you need to apply sort of early on if you want to be able to get a slot, but it's quite a helpful category again for individuals to come temporarily for up to 2 years. And the other route, and sort of we wanted to really flag, was the spouse route or civil partner. It could also be an unmarried partner if the individuals have lived together for 2 years. So basically the spouse or civil partner must be a British or Irish national, or it could be the person, someone who's settled in the UK that has indefinite leave to remain, or even if they've got pre-settled status or settled status in the UK, and the non-UK British national is coming to live with them here. It can be quite complex, this application, so it's definitely one to get advice on if this is relevant to anyone that you know. I'm going to pass on to Kerry now, who's going to finish off with business visitors and flag some points there.
Sorry, Jackie. Hi, I'll get my video back on. Right, apologies. So business trips. This too is just one to be aware of in case it catches you out post-Brexit, because even though there's no need for, say, a Spanish national to get a visa to come in as a visitor, they might well be questioned by immigration officials. And it's really important that they're able to show that they're actually coming in as a business visitor. And if the immigration officer feels that they don't meet the requirements of a business visitor, then they might be refused entry into the UK, or they could even end up being questioned for ages before they are admitted in. So it's just worth being aware as to what those requirements are. So most importantly, they need to intend to leave at the end of the visit. So we'd recommend you carry with you as a business visitor a return air ticket or Eurostar ticket. And the one that sometimes catches people out is they mustn't live in the UK for extended periods. So that includes where somebody's coming into the UK frequently. So let's say they come in for sort of 3 days a week, every week. That is quite likely to be regarded as basically making the UK your home through frequent visits. So just one to watch out for, where someone's coming in very frequently or for lengthier periods of time. They're probably going to start to be questioned about why they're coming in. They obviously need to have funds to cover their costs, but that's not generally a problem. The other big issue is making sure that they're not working in the UK. We just move to the next slide. So they're not allowed to work as a business visitor. So that obviously includes not taking up employment. It probably goes without saying in the UK. They also can't run a business as a self-employed person or sell or provide goods and services to the public in the UK. So just to be really careful about whether it falls on that side of the line, which is working, or whether I'll look in a moment at what you are allowed to do as permitted business activities. The other one where somebody might face extra questioning is if they receive payment or salary or fees from a UK company. That's going to raise alarm bells. So apart from a few limited exceptions, they shouldn't be paid by a UK company as a business visitor. So what can they do, you might ask? So that's set out on the next slide. So these are what we call the general permitted business activities. So these are things that are okay to do as business visitor. So if somebody's coming in for a short period of time to do any one or more of these things, that should be fine, as long as that's all that they're doing. There are a few other permitted business activities, but they're very specific. So they do with drivers or auditing, occasionally some IT ones as well. So it's worth double checking the rules around this, just in case there's another permitted activity. But on the whole, these are the main ones that we see on a day-to-day basis. They're really important to make sure business visitor is just doing this. And just worth mentioning that the immigration officers have quite wide-ranging powers. So if they're questioning somebody, they could ask to look at their laptop, their emails on their phones, any business cards they might be carrying. And if those suggest that the person is working in the UK, so if, for example, you've got a signatory which then says, you know, based in London underneath it, or if they've got a LinkedIn profile which suggests that they are working in the UK, that's likely to cause them problems if they're trying to come in as a business visitor. So just one to be aware of, because we are aware that there are people being refused entry post-Brexit on this basis. So just worth flagging as something to bear in mind. And before we move on to questions, just really briefly, we've obviously focused today on the immigration side. So key, the person's got the right to be working here from an immigration perspective. But really just headlines that there's obviously going to be a number of other things to think about. So if you do decide to employ somebody, let's say they've come over from an overseas group company, do you keep them employed by that company on a secondment arrangement, or do you put them on a local UK contract? Worth getting employment and tax advice on that. Bear in mind, anybody who's working in the UK is very likely to be entitled for UK employment rights. So that's going to give them a whole range of rights, some of which are set out on the slide. If you're moving data around, so let's say somebody's working in the UK, but their employer remains overseas, you might be moving their personal data. So just make sure that you're compliant from the GDPR perspective, and that you update your privacy notice as well. And finally, tax is obviously a really big one, tax, national insurance contributions and social security issues. And that's one where we'd definitely say take accountancy and tax advice, as this can be really complicated. And I mean, just before we move on to questions, I can see in the chat that there's quite a few questions about the tax status, particularly of interns. And I'm really sorry, but neither Jackie nor I are tax experts by any means. So those are questions that I'm afraid we're not going to be able to answer. And you would need to speak to your accountants or your tax advisors. And it will depend very much on the specific circumstances and how long the person's here as well. So I'm afraid we won't answer those questions. But I can see that there's obviously a number of other questions which we can run through. So we've got about 10 minutes and I will just pick those up between me and Jackie. So Jackie, I think you've probably seen one of the first questions is around, is there any sort of limit on absences in relation to somebody who's got settled status, or is it a lifelong status that they can basically never lose?
So once you get settled status, you're not sort of tied to that, making sure you don't spend more than 6 months of any 12-month period out of the UK. But you can lose your settled status once you have that if you're out of the UK for 5 years in a row. It's slightly less for Swiss nationals, 4 years. So you just need to be aware of that. So if the family relocate for sort of a long secondment or overseas, you just need to make sure you're back in time before you've been out for the 4 or 5 year period.
Yep, thanks, Jackie. And then just scrolling down, yeah, apologies, I can see a couple of tax questions which we can't answer. There's one around the interns and paying national living wage or national minimum wage. So basically, if you're going to be taking somebody on as an intern under the Tier 5 intern scheme, then the requirements to pay whatever the national minimum wage or living wage is for that age group. So if they're 18 to 20, it's going to be at the lowest rate. If they're older, and if they're 25 plus, you're going to hit the national living wage. So it's simply to mirror what you would have to pay a UK national in terms of national minimum wage. It's not higher than that, if that makes sense. Hopefully that answers it.
Kerry, about immigration skill charge. So the immigration skill charge is a payment that you make, say, for the sponsorship visa, so for a senior specialist skilled worker, an ICT or skilled worker. It's essentially a charge that the UK employer or UK sponsor pays per year of the visa. So if it's a medium or large company, that's £1,000 per year of the visa. So for a 5-year visa, 5,000. If it's a small company or a charity, I think it's 364 per year. So about 1,800 for the 5 years if you're going for a 5-year visa. So it does add up to for the fees for the UK sponsor, certainly for sponsorship.
It's kind of a levy, isn't it? I mean, it's just an additional charge which the government imposes for the privilege, as they put it, of hiring somebody from outside of the UK. I think it was also intended as a deterrent to try to get people to recruit UK nationals. So that's sort of why it was there.
And there's a few questions on the high potential individual route, which shall I take, because I went through that part. So one of the questions is, would the high potential individual route, where you can bring certain dependents with you, could they work in the UK? Certainly that's what we're anticipating, that the partners, spouses who qualify as dependents would be able to work in the UK for any employer or self-employment. And there's another question on this route, high potential route. Would there be a time frame for when the individual must have graduated? So they must have been awarded their degree from that specified university on the list in the 5 years before the application submitted. So there is that sort of 5-year maximum period from when they were awarded the degree.
And then there's a question on business visitors. So the person has said, what's the case for those foreign suppliers, e.g. capital goods, who send employees to do the setup at a British client's premises? I think that's one where you'd have to really understand the facts. I'm afraid it would be very fact specific as to exactly what are those employees coming over to do. Does it fall within one of the permitted business activities? How long are they spending here? And there's a chance that it might be that it trips over into actually undertaking work if it doesn't fall within one of those permitted activities. So it's definitely one to take advice on. I mean, potentially it could be that the new service supplier route is useful there, and you actually need to work out a sponsorship route. But I think it's difficult to answer that without more information. I'm afraid it would need quite specific advice on that one. There's a question, does the business trip scheme, which I'm assuming is sort of business visitors, does it apply to someone fully qualified in the UK before Brexit? I'm not quite sure entirely what's meant by that, but it would apply to anybody who is coming in who doesn't have other immigration status. So if they don't have pre-settled status, they don't have settled status, they haven't got leave under any of these many categories we've talked about, and they want to come in as a business visitor, it would apply to them. But I'm not sure I can say any more on that.
There's a question on the youth mobility scheme as well. What are the chances of this scheme being extended to include some or all of the European countries in the EU? There were rumours that might happen, and the scheme could be extended in the future. There's certainly nothing that I've heard that's in the pipeline. We can only hope that might be the case in the future, but at the moment it is limited to those 11 countries on the list.
Yeah, I think it's been one of the huge disappointments, hasn't it, that you haven't got that ability for young people, either for British to go to Europe or Europeans to come to Britain. So I'd be really hopeful one day we'll get there again with that, but it has to be reciprocal, and I think that's part of the issue. It's getting every country to agree to this that can be tricky, but hopefully one day, as you say, Jackie.
Yeah.
And then just having a read of this. There's another question that's come in. Yeah, again, I think these questions around business visitors and contractors, I'm afraid, are so fact specific. It's very difficult to give you any meaningful sort of answer at the moment. So again, it very much comes down to how often are they coming in. The minute that they're starting to come in sort of very regularly, so, you know, come in for a period, go back to Spain, come in again, you really are going to be flagging questions being asked. There is guidance on the website. We could send out, actually, Hannah, if you remind us afterwards, what we can do is just send out a link with the slides to the business visitor guidance, which will give a little bit more information. But it's one of those areas, I'm afraid, where businesses need to take quite specific immigration advice on what you need to do there. There's quite a few strategic things to think about. So I think, sorry, I just jumped up. I think that was that it? I know, Jackie, sorry, can you see any others? For some reason it's jumping around.
So we issue all transfers from Spain to the UK as secondment contracts because they're here short term. Is it worth thinking of getting the new temporary route, or should we stick to our intra-company transfer route? I assume you're talking about the secondment worker route there as the new route. I mean, that is very much limited to, you know, a contract worth at least £50 million. So I think it sounds like probably this senior specialist worker, the old ICT route, would be the most appropriate one still to use potentially, or you could think about using the skilled worker route, you know, if their English language is good enough. Is the standard skilled worker route more onerous? No. So as Kerry was saying, between the skilled worker and the old ICT, now called the senior specialist worker, the main difference really is, you know, the English language requirement is required for the skilled worker, whereas it isn't for the senior specialist worker. But the senior specialist worker doesn't lead to any sort of permanent residency rights, whereas skilled worker does. So really, you know, unless there's a good reason to use the old ICT, the senior specialist worker route, you know, you might want to consider using the skilled worker route from now. It's pretty much the same process, same fees.
Yeah, I think that's right. We'd tend to encourage skilled worker where possible, because it just gives greater flexibility if you decide to keep the person longer. They've sort of started to accrue time towards indefinite leave. That's the main reason.
There's also a question, Kerry, about the service supplier route. So where the employees aren't qualified at the sort of graduate RQF level 6 requirement, but have necessary experience. So how you'd go about this.
Yeah.
So yeah, we haven't obviously done one as yet. They've just come in, but there'll be a way to submit all of the required qualifications and experience as part of the application. I would imagine it'll be quite document heavy. Yeah,
it will, and it depends so much as to which trade agreement it falls under, because some of the options are only available under particular trade agreements. So again, it gets, I'm afraid to say, so specific to the circumstances. Yeah, we need to speak to you on an individual basis about that.
I think that's all of them. Yeah, that you've, thank you so much. Yeah, that was very, very thorough. I just wanted to mention that, so I'll be sending around an email after this, which will contain the recording of this webinar in case anyone would like to watch it again or to share it with a colleague or contact who you think would find it useful. I'll also be sharing the slides that Stevens and Bolton have very kindly shared with us, so you can refer back to those at any point. And I'll also share Jackie and Kerry's email addresses, so if anyone has another follow-up question that occurs to you at a later point, please, or you'd like to obviously indeed find out more about the immigration services that Stephen and Bolton offer, which we can only recommend extremely highly, please do go ahead and get in touch with them about that. But yes, thank you so much, Jackie and Kerry. That was an incredibly informative and very, very useful session this morning. We really appreciate you sharing all that information with us and answering everyone's questions. And yes, yeah, I hope everyone found that useful. And yeah, I hope we see you all again soon at another Chamber event. Thank you very much.
Thank you.
Thanks.
Thanks. Have a great day, everyone.